Picture this. You're driving through Nevada, valid concealed carry permit, FBI background check passed, certified training completed. You've carried responsibly for years without a single incident. You cross into California. California law says you are now a felon, not a suspect, not someone under investigation, a felon, for exercising a constitutional right that 35 other states respect without question. The same background check, the same training, the same clean criminal record. California looked at all of that and said none of it matters here. That system just died in federal court. And the ruling didn't just strike down a law. It exposed a constitutional crack so deep that it threatens the entire legal foundation that California, New York, New Jersey, and Hawaii have built their gun control systems on for over 2 decades. I'm Sarah from Firearms Law Advisor, 5 years in the firearms industry. And what Judge Patricia Ramos just issued is not a temporary win California can work around. It's a permanent injunction. And the equal protection framework behind it is already being deployed in federal courts across America. Before we go further, Firearms Law Advisor exists for one reason: to bring you the Second Amendment legal battles that mainstream media refuses to cover. Clear, accurate, no spin. Just the law and what it means for your rights. We are a brand new channel and we need your support to grow. Hit that subscribe button right now and turn on all notifications. When California appeals this ruling, when the Ninth Circuit decides on a stay, you need to know within minutes. Drop your state in the comments immediately. And tell me, have you ever been denied your carry rights because your home state permit wasn't recognized when you traveled? I personally respond to every single comment. Let me show you exactly what California was doing to out-of-state gun owners, because the absurdity of it is exactly what made this ruling inevitable. If you are a California resident and you want a concealed carry permit, you go through the standard shall issue process: background check, training, application, standard procedure. But if you are a visitor from Texas, Florida, Arizona, Nevada, anywhere, with a fully valid permit from your home state, California didn't recognize it at all. Your Florida permit, which required FBI background checks and certified training, meant absolutely nothing at the California border. Your Texas carry permit, backed by documented training and a clean criminal record, worthless. California treated you as carrying illegally, and they were prepared to charge you as a felon for it. Think about the logic California used for 20 years. You passed the same federal background check every licensed gun owner passes. Your home state verified your record, your training, your eligibility. California looked at all of that and said, we don't trust any of it. You have no rights here. FBI crime data tells the real story. Out-of-state permit holders commit violent crimes at rates lower than off-duty law enforcement officers. California wasn't protecting anyone. They were discriminating against law-abiding Americans based purely on which state issued their permit. Comment right now, what state are you watching from? And have you ever been denied your carry rights while traveling because your home state permit wasn't recognized? Drop your state and what happened. I want to see exactly how many viewers this discriminatory system directly affected. Let me walk you through Miller versus California, because the way this ruling happened is as significant as the ruling itself. Earlier in 2026, federal judge Patricia Ramos issued a preliminary ruling declaring California's non-reciprocity law unconstitutional. That alone was a major win. But California did what California always does. They came back with a workaround. Instead of eliminating the discriminatory system, California proposed an entirely new system for non-residents to apply for carry recognition. 6 pages of requirements, county-specific applications, multiple sworn affidavits, restrictions that California's own residents are never asked to meet when applying for the exact same permit. The legal team challenging the law brought this response back to Judge Ramos with one direct argument. Constitutional rights should not require citizens to navigate an administrative maze designed to make compliance practically impossible. You cannot replace one unconstitutional system with a different unconstitutional system and call it compliance. Their demand was simple. Don't fix the process. Eliminate the law. On August 19th, 2026, Judge Ramos agreed completely. She did not just reject California's workaround. She issued a permanent injunction blocking enforcement of the discriminatory law entirely. No complicated application process. No county restrictions. No additional affidavits. The law is unconstitutional and cannot be enforced. Period. Full stop. Tell me in comments, which anti-gun politician do you think is most responsible for the 20-year system that just got permanently enjoined? Name them directly. I want to see who this community holds accountable. Here is what makes this ruling so dangerous for anti-gun states across the country, and why it travels far beyond California's borders. Judge Ramos did not decide this case on Second Amendment grounds alone. She applied the Equal Protection Clause of the 14th Amendment. And that distinction is enormous. The legal standard she applied is called strict scrutiny. When a government creates a system that treats two groups differently for exercising the same constitutional right, it must clear two very high bars. First, a compelling state interest for the different treatment. Second, the least restrictive means of achieving that interest. California failed both tests. Convincingly. Compelling interest? None. FBI data shows out-of-state permit holders commit violent crimes at lower rates than off-duty police. There is no evidence non-residents with valid permits pose any public safety risk residents don't. Least restrictive means? The opposite. That 6-page county-specific sworn affidavit application system was deliberately designed to maximize burden and minimize compliance. The court saw it clearly. And here is the critical strategic advantage of this equal protection framing. Courts that are skeptical of Second Amendment arguments find it much harder to dismiss a straightforward argument about treating Americans differently based purely on their state of residence. This isn't just a gun rights argument. This is a fundamental equal citizenship argument. Drop your answer in the comments. Which state do you think gets challenged next using this equal protection framework? Type New York, Hawaii, New Jersey, or Massachusetts, because within 72 hours of this ruling, 3 new federal lawsuits were already filed. The precedent is already in motion. Here's why this ruling doesn't stay in California, and why every restrictive state in America should be alarmed right now. New York has 0 reciprocity agreements with any other state. Under Miller versus California's equal protection framework, that's a constitutional violation. Hawaii treats non-residents differently for the same right. Strict scrutiny failure. New Jersey effectively bans all non-resident carry. Unconstitutional under this reasoning. Massachusetts. Maryland. Connecticut. All of them running the same discriminatory system that just got permanently enjoined. Within 72 hours of the ruling, 3 new federal lawsuits were filed. 1 in New York, 1 in Hawaii, 1 in New Jersey. All 3 cite Miller versus California directly. The legal blueprint is deployed and moving through courts right now. And here's the economic dimension that is building real political pressure simultaneously. Tourism analysts estimate reciprocity restrictions cost states like New York nearly $847 million annually in lost tourism revenue from travelers who refuse to visit states where they cannot legally carry. California's losses projected even higher. When you combine expensive federal litigation that states are increasingly losing with massive economic costs, the political calculus for anti-gun legislators starts to shift. The financial pressure is real. It is accelerating. And it is creating the kind of combined legal and economic pressure that eventually forces even the most resistant states to change. Comment your prediction. If New York is ultimately forced to recognize your out-of-state carry permit, would that change whether you visit or do business there? Type would visit or still avoiding, because the economic argument matters enormously, and I want real data from this community. A permanent injunction is a major win, but the legal fight is not finished. And understanding what comes next is as important as understanding what just happened. California's Attorney General will almost certainly appeal to the Ninth Circuit. When that happens, the court decides whether to grant a stay, pausing the injunction while appeal proceeds, or deny it and let the permanent injunction stand immediately. Historically, the Ninth Circuit sides with California on gun control. A stay is a realistic possibility in the short term. But here's what changes the calculation. Equal protection arguments carry different weight than standard Second Amendment arguments. The principle that you cannot deny Americans their constitutional rights based solely on their state of residence has deep, broad support across all of constitutional law. Even judges skeptical of gun rights expansion struggle to cleanly dismiss that argument. And if this reaches the Supreme Court, the current 6-3 conservative majority has consistently ruled in favor of expanded Second Amendment protections. The Equal Protection Foundation gives this case two independent constitutional legs. That is a very strong position before this court. Here is your practical guidance right now. If you travel to California regularly, monitor this case extremely closely. Do not change your carry behavior based on the current injunction without checking for updates. If California gets a stay, enforcement could resume. Act on what courts formally order, not on what you expect. If you live in New York, Hawaii, New Jersey, or Massachusetts, the lawsuits filed in your circuit citing this ruling are the cases to watch right now. Contact Second Amendment Foundation, Firearms Policy Coalition, and Gun Owners of America. They are actively looking for plaintiffs in these challenges. Tell me in comments, are you already in contact with a gun rights organization about challenging reciprocity laws in your state? Type already involved or want to know how, and I will personally point you in the right direction in the replies. Here's the bottom line. Miller versus California just delivered a permanent injunction, eliminating a 20-year discriminatory system that treated law-abiding Americans as felons for crossing a state border. The equal protection framework behind that ruling is already deployed in New York, Hawaii, and New Jersey. The constitutional crack this ruling exposed threatens the entire legal architecture that every restrictive state has built their gun control systems on. California will appeal. The Ninth Circuit will decide on a stay. The Supreme Court may ultimately rule. But regardless of the procedural battles ahead, the constitutional principle has been stated clearly by a federal court. You cannot deny Americans their Second Amendment rights based purely on which state issued their permit. That is discrimination. That is unconstitutional. Courts are finally enforcing that truth. Here's what you do right now. First, subscribe to Firearms Law Advisor and hit that notification bell immediately. This is a brand new channel, and every subscriber gives us the motivation to keep bringing you this coverage. When the Ninth Circuit rules on the stay, you need to know within minutes. Second, smash that like button and share with every gun owner you know who travels or has ever been told their rights end at a state border. Every like and share helps our new channel reach the gun owners who need this information. Third, answer every question I asked. What state are you in? Have you been denied carry rights while traveling? Which state falls next? Would you visit New York if reciprocity is forced? Already involved with gun rights organizations? Drop everything in comments. I personally respond to every single one. Fourth, any questions about how this ruling affects your state specifically, ask me anything below. 5 years in this industry. Real answers only. Constitutional rights do not stop at state borders. Courts are finally enforcing that principle. Stay informed. Stay legal. Know your rights. I'm Sarah from Firearms Law Advisor. See you in the next one when California files their appeal.